Welcome to the Minnesota Association of Realtors e-video resource. My name is Chris Galler. Today we're going to discuss the MARS disclosure and information. Now you're going to say, why are we talking about MARS? MARS stands for the Mortgage Assistance Release Service Act. It's done by the FTC. And today we're going to discuss it so that you can implement it into your business practices. This is a disclosure about the purpose of the video. The video shall serve as an overview only, and each individual Minnesota Realtor member shall make his, her, or its own decision on when and how the MARS rule applies and how to comply with the rule. Members with questions are urged to discuss such questions with their broker and/or their legal counsel. A little background on the FTC. They issued a federal regulation aimed at mortgage assistance relief services. These are the companies that advertise, send me $2,000, $4,000, or some other amount of money to negotiate with your loan company. The FTC believed there was about 550 of these companies nationwide. Upon reviewing the language, NAR became concerned that the rules would apply to realtors working with sellers in short sale situations. Since then, NAR has been negotiating with the FTC for over a year now, trying to get them to modify some aspect of their regulations. As recently as mid-May, a webinar announcing modifications was canceled when NAR and FTC could not agree on terms. The FTC is concerned that some inappropriate MARS providers will open or affiliate with real estate firms in an attempt to avoid the regulations. It is also important to keep in mind that this is a disclosure law, something the industry generally believes in. MARS has 3 separate and distinct disclosures. A little bit about compliance. Beyond the consumer disclosures, the federal regulations also require all ads, sales records for MARS transactions, contracts, communications, and disclosures be retained for 2 years. It prohibits the collection of upfront fees. Brokers and agents should examine and revise any scenarios in which upfront fees may be collected to ensure this prohibition is not being violated. Rule applies to those who arrange for negotiations. It is possible that the referral of a client to a MARS provider could be construed as arranging such services, thus requiring the referrer to provide the disclosures. What is my association doing? On top of leasing forms and other updates, your Minnesota Realtors Forms Committee members have been reviewing and discussing how to implement the MARS regulations since we first made the members aware of this issue in March. As information about the NAR-FTC negotiations became available in mid-May, the Forms Committee and Legal Counsel have worked quickly to produce forms and informational guidance for you to use. Please review Brad's memo, which is very complete and should be helpful to brokers considering how to revise and establish appropriate office policies. What are the disclosures? The required disclosures include 1. A general commercial communications disclosure, 2. Consumer-specific commercial communications disclosure, and number 3. Offer from lender disclosure. We have a separate video that you can view that deals exclusively with the disclosure forms. Important for you though, depending upon what is being communicated, when and to whom, any or all 3 of the disclosures may be necessary. It is up to each individual real estate agent, broker, and real estate company, each MARS provider, to determine when it is necessary to make such disclosure and what disclosure must be made in each scenario. When to use disclosures. For real estate brokers and salespersons specifically, who are the sole focus of this memo, the National Association of Realtors has noted 4 specific instances when a real estate broker or salesperson may be covered by the rule and is required to provide the above referenced disclosures. These include 1. Advertising short sale negotiation services or other short sale expertise. Communicating with the consumer about a possible short sale prior to the listing agreement being executed. 3. Negotiating a short sale on behalf of a consumer. And 4. Arranging a short sale for a consumer, collectively referred to herein as MARS services. Penalties. With all federal, state, and local regulatory matters, penalties are part of the equation. Mars penalties are significant, $16,000 per violation, monetary damages to consumers, and if that's not enough, the Minnesota Attorney General can become involved. It is essential that real estate brokerages offering Mars services understand the content and procedures associated with each of the disclosures, and that disclosures are made in a timely and proper manner as required by the Mars rule. For your assistance, the Minnesota Association of Realtors has prepared 3 disclosures as MNAR forms which members may use. In the event the Mars rule or its interpretation evolves, the Minnesota Realtors will make every effort to update the disclosures as necessary. Please view the next video, Understanding the Mars Rule, Mandatory Disclosures. Thank you for tuning in today. We hope that you enjoyed this and have a broad overview of what the issue is. Have a great week.